नमस्कार दोस्तों। आज का डेली लीगल न्यूज़ में जो फर्स्ट न्यूज़ है कि सुप्रीम कोर्ट एक्चुअली रिफ्यूज टू एंटरटेन अ 2023 जजमेंट, जहाँ पे बेसिकली जस्ट ओनली शोइंग क्रिमिनल कॉन्स्पिरेसी यू कैन नॉट अप्लाई द पीएमएलए एक्ट। तो इसका मतलब है इन ऑर्डर टू अप्लाई फॉर अ पीएमएलए एक्ट यू हैव टू शो दैट देयर इज अ प्रोसीड्स ऑफ क्राइम एंड द क्राइम इज रिगार्डिंग एनी काइंड ऑफ एक्टिविटी रिगार्डिंग एनी काइंड ऑफ मनी लॉन्ड्रिंग। तो आपका जब ये टू एलिमेंट्स रहेगा तभी यू कैन अप्लाई द पीएमएलए एक्ट, अदरवाइज यू कैन नॉट अप्लाई। And because of only there is a criminal conspiracy to just show, then the act cannot be applied, and it was actually 2023 का एक जजमेंट था जिसको रिव्यू एक्चुअली ईडी ने किया था, जिसको सुप्रीम कोर्ट ने डिसमिस कर दिया बेसिकली। अब जो सेकंड न्यूज़ है ये भी काफ़ी इंपॉर्टेंट है। बेसिकली दिस न्यूज़ इज इम्पॉर्टेंट इन फैक्ट दैट इट कैन बी टेकन एज अ रेफरेंस बिकॉज सुप्रीम कोर्ट इन अ 2013 murder case in Delhi has actually directed CBI to go for an investigation and has directed that the investigation should be reopened and the CBI should actually thoroughly make the investigation, because they are saying that when there is a public trust and उस public trust का basically कुछ undermine होता है, because when there is a large scale any serious offense and it actually has any kind of public effect, so in that case the particular crime can be reopened even after a long time. So this judgment can be taken as a precedent where if there is a public large cause is there in that particular case, basically the judgment can be very useful and that particular case can even be reopened after a long time also. In the third case, basically Supreme Court has said in the Bloomberg versus G Telefilms way, basically when the any kind of material is there in the news or media, and without even looking at that particular news, if any kind of injunction or gag order is passed against this particular news, and that is the violation of the fundamental right. So basically, let's say if there is any article, first prima facie it has to be proved that that is malicious or frivolous. मतलब वो article basically झूठा है, तभी जाके you can actually stay, make any kind of injunction order and things like that. Now coming to the fourth news, it says that it is also important news. Basically, they said that when there is any kind of offense under Drugs and Cosmetics Act, mere filing a complaint by a police officer cannot institute that particular case. It means when there is a competent jurisdiction lies with a different officer, that is, let's say, drug inspector or let's say drug and cosmetics, at if there is any other provisions like any food safety inspector in other places. So basically, in those particular cases, those people have inherent right in order to file a complaint or a complaint on basis of an individual, and if there is a proper investigation in this regard, then the complaint can be done. And if a police officer so moto does it, then he is not to be considered an expert in that particular matter. And जब वो एक्सपर्ट नहीं होता है, तो कोर्ट इसको बेसिकली डिसेंड किया दैट ही डज नॉट हैव द कॉम्पिटेंसी टू फाइल अ कंप्लेंट अंडर दैट पर्टिकुलर एक्ट। नाउ कमिंग टू द फिफ्थ न्यूज़, सुप्रीम कोर्ट ने बोला कि व्हेन अ जुवेनाइल इज टू बी basically tried as a adult under the section 15 of the Juvenile Justice Act. In that case, a proper report is required by the Juvenile Justice Board regarding the mental and physical health condition of that particular child in order to try that as a basically adult. Because when this juvenile is being tried as an adult, the proper report is necessary and detailed report. Otherwise, the matter is inherently going to be violation of the fundamental right. अब सिक्स बेसिकली एक न्यूज़ है जहाँ पे बेसिकली सुप्रीम कोर्ट ने बोला कि देयर शुड बी ऑलवेज क्रॉस एग्जामिनेशन of any witness who is being asked in any kind of warrant case. That means any case where there's a punishment of more than 2 years. In this particular case, what happened? The Supreme Court observed that while the this particular case was regarding cheating, and all of this particular prosecution witnesses, जो basically उधर पे गवाही दिए in the court, none of the people had any kind of was they were not crossed. Only the examination was done by the prosecution, and even the accused did not have the proper representation in this regard. So Supreme Court that's why observed that when there is going to be an examination of chief of any witness, that means that a person is going to be called as a witness, then always that person has to be crossed in order to understand the veracity of that particular witness. तो दोस्तों आज के लीगल न्यूज़ ट्विटर में यही है सुप्रीम कोर्ट का। तो आप ऐसे ही बहुत सारे लीगल न्यूज़ जानने के लिए मेरे चैनल को सब्सक्राइब कीजिए। धन्यवाद।